In a last-minute ruling in Texas Southern District Federal Court, Judge Andrew Hanen ruled in favor of 26 states' legal challenge to President Obama's executive action that would expand programs to hundreds of thousands of immigrant children and their parents living in the country without documentation. Here with local reaction and the legal ramifications are my guest, legal analyst Dan Eaton and immigration attorney Lilia Velasquez. Lilia, remind us of what this what the executive order was from President Obama.
We had an expanded DACA, which actually removed the age cap. It was, 35 years old. Now you can be 40 and still qualify for DACA if you meet the other requirements. The other major change is that you can, as long as you have resided in the U.S. since January 15th of 2010, you will qualify. Before the date was June 15th of 2007. So a lot more people will qualify under the expanded DACA.
And just remind people what DACA is, who that applies to.
It applies to primarily students, the dreamers, that's why we call them the dreamers, who have completed high school, who were under the age of 16 when they came to the United States, and who do not have any serious criminal past. And they can present their high school diploma, or at least proof of enrollment in the GED program. So very narrow categories, and they were anticipating 1.4 million would apply, and that figure is cut in half. And so now they're expanding, and we're hoping that more of the dreamers will qualify. And the second part was DAPA for the parents who have U.S. citizen children, or lawful permanent resident children who have been here for the last 5 years, and also they're law-abiding citizens.
Okay.
So,
okay, and Dan, on the legal side of this, about 24 states, including Texas, challenged the president's authority to have this executive order. What are their legal arguments?
Well, their basic arguments is that he went too far, that this was really lawmaking. This was not administrative, and he violated the Administrative Procedures Act, which requires the public to have notice and to be able to weigh in. And the judge, in his 123-page ruling, said, you know what, on the procedural aspect, maybe they should have given public notice, and I'm going to block this order because they didn't. This feels more like a substantive change as opposed to a general policy pronouncement where the president has some broad latitude.
Well, President Obama has vowed to fight this and says he would win a legal battle. He said, quote, he'd prevail in a legal battle on this. What's the constitutional right of a president to use executive order on immigration policy?
Well, Peggy, it starts with the president's broad power over immigration policy. Remember, immigration is fundamentally and exclusively a federal question. The only reason the states are involved at all is because they say they're going to be hurt, because they're going to have additional expenditures, because it's going to authorize certain people to remain in this country. So the president has broad action. As far as deferred action, that's a little bit more difficult to determine whether he has specific authority like that. But the bottom line is that the president has broad power to decide how to allocate certain resources in prosecuting wrongs about immigration or other laws.
Well, Lily, even if the president wins this legal battle on appeal, what effect is this court challenge having on immigrants, I should say, here in San Diego?
Well, it's going to legalize, temporarily at least, a large segment of the immigrant population in California. We're the most populated state as far as immigrants is concerned. So California is in the forefront. And so you would have parents that would be able to get a permit to work and be here with the children. And then you would have a larger group of dreamers who would qualify for DACA. So the effect is going to be phenomenal.
Sure, if it goes through. But I'm wondering, what about the effect, this challenge, the court challenge? Is there some doubt in the community? What's happening as far as, because this challenge is on the table now?
What I have seen so far is that some people who were very skeptical, they're saying, you see, attorney, I told you, it was a lie. And so now they're very, very, they're thinking as to whether or not they want to apply. But the other segment of the people, and I think that's the majority, who are saying, yeah, but they keep telling us that the president will win. Of course the president will win, and it's just going to take a little longer. We tell the people, continue to gather your documents so we can, file your case. Don't give up.
Let's talk about that time frame, Dan. If this injunction is overruled in an appeal, can that appeal be appealed, and how long could this be tied up in the courts?
Well, how long is the answer is blowing in the wind when you're talking about law. But the bottom line is most people expect the appeals to be expedited, meaning that they're going to move this along. And yes, it could go all the way up to the Supreme Court eventually, but this will be wrapped up. We'll know the final answer to this before the end of this year, Peggy.
All right, Attorney Dan Eaton and Attorney Lilia Velasquez, thank you so much.
Thank you.